Lawyers. What is the strangest law that's won a case for you? I'm not a lawyer, but I have a story from Australia. I received a letter from SDRO, State Debt Recovery Organization, stating that I had unpaid debts. They gave me 30 days to pay them, otherwise they would be arriving at my home to repossess everything I owned, including furniture. Furniture was specifically mentioned in the notice. This really annoyed me. I'd never had unpaid debts. In addition, I lived in an apartment with my brothers. Who were these clowns to threaten that they would take all my furniture and belongings with 30 days' notice? When I checked the details of the notice, it was for unpaid traffic fines from more than a decade ago. The most recent notice was from 13 years ago. The oldest was from 15 years ago. With interest and other penalties, they wanted a couple of $1,000s. Big money to me at the time, 20 years ago. Now when I was in my early 20s, I did have a motorcycle. And I did rack up a few speeding fines, but I paid them. Back then, you had to pay them because if you didn't, your license would get canceled. My license had never been canceled. I paid the fines by money order. After about 5 years, I got a new wallet, looked at the stubs for the money orders, laughed at myself for being paranoid and threw them out with my old wallet. Surely no one would want them by now. And a few years later, these notices arrived. I called SDRO to say these charges were invalid. They had been paid years ago. They said no problem, we just need a letter from the issuing authority to say so. I checked. The issuing authority no longer existed. It had been closed down years ago, and a new government authority, the RTA, now existed. I called the SDRO back and they said, sorry, but unless the relevant authority says the debt has been paid, we cannot cancel. But the relevant authority no longer existed. It seemed Kafkaesque to me. I then called the Sydney Central Court. One of the clerks there took pity on me and gave me a huge tip. They shut down the old government authority and started up the new one. They had, of course, had to transfer records from the old one to the new one. She thought my payments might have been made at the time of the transfer and somehow not recorded in the old system or the new one. My first clue. I contacted the SDRO again and told them I believed these debts had been paid and had been accidentally resurrected in the course of switching systems. This time one of their lawyers wrote to me and said I had not proved this was the case. True, and that the debt still stood. And here's where I had my moment of genius. I told them the debts were paid and because 7 years had expired, I no longer had to provide proof that I had done it. In the letter, he told me that because the debts were for traffic offenses, they became a criminal matter, did not expire after 7 years and still stood. My next letter, I told him it only became a criminal matter if they were unpaid. However, I said they had been paid, therefore they were no longer a criminal matter, and therefore I no longer had to supply proof they had been paid. His next letter, you have to prove they have been paid, until then it remains a criminal matter. My next letter, as you are claiming a debt against me, I don't have to prove they are unpaid. Instead, it's up to you to prove they were. In fact, because the debts you're asserting are so old, there has been a denial of natural justice. The law says I don't have to retain receipts for more than 7 years, but by trying to collect on a debt so old, you're trying to force me to supply proof that according to the law, I no longer need to have. For there, I escalated things to the ombudsman. And I won. Or the ombudsman did. The debts were cancelled or assumed to be paid off. I'm glad I won in the end, but can you imagine receiving claims for debts more than a decade old? How ridiculous and unfair. Now, 30 years later, we have robo-debt in Australia, and I suspect it is illegal to try to force people to prove things about their income from more than 7 years ago. Sounds to me that they just wanted money. Story 2. I'm not a lawyer, but I have done enough law research to get myself out of a parking ticket once. When I was in college, I was in the marching band. We had a storage room in the basement of one of the dorms. I was going to get something out of the storage room and park in the loading dock behind the dorm. There was just enough room next to a dumpster to fit my car. I didn't want to spend $5 on a loading zone pass from parking services because I was a broke college student, so I just parked. I was only going to be there for 2 minutes anyway. I finished picking up what I needed, and sure enough, I came back out to my car to get a parking ticket. Except it wasn't a $25 ticket for parking in a loading zone. It was a $75 ticket for parking in a fire lane. What the heck? There was a single sign at the very front of the side road leading up to the loading zone, but there was no curb paint and no indications of where the fire lane started or where it stopped. I called parking enforcement, telling them this, and they wouldn't budge. Fine. I took pictures of the loading dock and I submitted an information request to obtain the evidence. I got the pictures and started researching fire lane requirements in the state. What I found clearly indicated that curb stripes were mandatory. I called parking enforcement and told them what I found, but they still wouldn't budge. Frustratingly, I looked at the law again. The part they cited me for said that nothing could obstruct a fire lane at any time. I looked back at the evidence photos and saw the dumpster next to my car. If this was a fire lane, then the dumpster was blocking the fire lane too. The same state law they cited me with said that non-vehicle obstruction of a fire lane was subject to a fine of $1,500 a day. I found satellite imagery from 4 years prior showing that the dumpster had been there for at least 4 years. So I argued to university parking enforcement that if this was a fire lane, then the university had been obstructing it for at least 4 years and would owe the state $2.2 million in fines if I reported it. The parking ticket disappeared immediately when I sent the appeals committee their own evidence photos, satellite imagery, and the same state law they cited me with. I drove by a week later and the dumpster was gone, the curb was painted, and 2 brand new fire lane signs were up. Story 3. I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip-and-fall case where my client tripped in a piece of broken sidewalk outside of the Natural History Museum and injured her arm and wrist. The law states that a property owner is responsible for the sidewalk directly outside of their property. The theory is that, even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very, very stupid law that they would be exempted from the rule that they can't be sued for sidewalk injuries unless you can show there were a notice of a hazard. Meaning you would have to show that you informed the Secretary of State or Governor or Mayor, etc. of the exact specific crack in the sidewalk before the injury occurred. And you had to do so in writing with ample time for the city to remedy it, 180 days in advance if I remember correctly. Under normal circumstances, this is impossible because no one anticipates tripping on the sidewalk 180 days in advance, with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight. There was a nonprofit called Big Apple Maps which would go around the city with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazards, and then publish these maps while serving copies on the government, with the express purpose of combating sovereign immunity defenses and slip-and-fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" And I gave them the map. Immediate settlement. That was a really nice gotcha moment. Story 4. Prior to becoming an attorney, I worked in retail for a few months. The way my assistant manager scheduled me, I had to work 10 days straight, including a couple of 12-hour shifts, with no days off and minimal overtime. They got around the overtime by scheduling me for the last 5 days of one week and the first 5 days of the second week, so I only worked 40 hours in the work week plus the 4 hours of overtime for the 12-hour shift. That did not seem right to me, so I looked up the law in Virginia. While they could technically do that, there was an archaic law at the time in Virginia that stated if a non-essential or non-managerial worker wanted Sundays off, the job had to give the Sundays off without penalty. This was true even if the worker agreed to accept the job and work on Sundays. The worker, under the law, could change his or her mind and ask for all Sundays off. As long as the worker was not essential or a manager, then the employee had to accommodate. I took the law to my manager and said that I was not going to work Sundays anymore. He said that they wouldn't schedule me that many days in a row anymore, but I still had to work Sundays. I told him that I did not, and I gave him the statute. It caused a big stink, and I ultimately found a better job not long after, but I never worked a Sunday there again. Ironically, a few years later, the Virginia General Assembly accidentally created a law that nullified the essential worker and manager bits of the Sunday law. That made the news, and suddenly, people were aware of this archaic law that they could ask for Sundays off. I remember the news saying that no one knew about this law because I thought to myself, I did. The General Assembly repealed the entire law about Sundays, so now workers do have to work Sundays. That was the only time, though, that I found an archaic law to help me out. Story 5. The weirdest case I've dealt with was Jolie vs. Pelletier, 1999, Ontario Judgments, number 1728, Superior Court of Justice. I did some research for this case when I was a law student. Some background. This was at a time when the Ontario Court of Appeal had held that if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That is not the case today. It was discovered that this position basically ruined summary judgment as a useful process, but it was at the time. In such a motion, all facts alleged by the plaintiff would be assumed to be true. What happened was this. A man sued, among others, the College of Dental Surgeons for persecuting him and interfering in his ability to live as a generic Martian. The plaintiff claimed he had been cloned from space debris NASA found in the 1960s. He claimed he had a genetic test to prove this, but it had been falsified by the CIA as part of the conspiracy against him. Well, naturally, this claim raises the concern that the plaintiff was bonkers, but there was no evidence, aside from his bizarre claims of that. In court, the case was decided on 2 alternate grounds. First, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on the more entertaining basis of standing. Justice Epstein held that only a person could commence an action in Ontario. The rules of civil procedure define a person to be either a human being or a corporation. The plaintiff's whole case was based on his being a Martian. If he was not a Martian, his case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. That's some next-level creativity right there. But hey, in the world of law, anything goes until proven otherwise. If you're enjoying these crazy law stories so far and are up for more, hit the like button and subscribe to the channel. The incredible workplace tales don't stop here. Story 6. There was a case here in Hawaii that got thrown out like this. Someone got pulled over because the police saw he had way too many passengers in the car. Then they noticed she was intoxicated. It was an open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle. So the issue was that all the extra passengers weren't wearing seatbelts. Well, this also failed because the law only says that every available seatbelt needs to be in use. If you have 6 passengers and only 5 seatbelts, there's nothing at all illegal about the 6th being unrestrained. So since there was no probable cause to pull her over in the first place, even though she indefensibly had a few too many drinks, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they can just party back there while anyone in the cab unbuckled will get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs. Also, a related story. I had a roommate who got picked up for public intoxication on St. Patrick's Day. He was in jail for a couple of days, which seemed odd for a PI. It turned out he had a warrant from another city for escaping jail. The year before, he also got picked up for public intoxication on St. Patrick's Day. He had a hazy memory of being shuffled down a hallway with a bunch of other tipplers at the jail before walking through a door and suddenly being alone outside. From there, he just walked home. The police never came looking for him, so he wasn't even sure it happened. Anyhow, it turns out they never even properly booked him. So while there was a warrant for him, there was no record of him ever being arrested. Case dismissed. Story 7. I had a guy in USAF basic training who should have been a lawyer. When pulling dorm guard duty, we were supposed to ask anyone requesting entry to show their military ID through the window in the door and compare the names shown to an approved entry list. Failure to confirm ID before allowing entry was a security infraction. So this one dude is a dorm guard when a TI, training instructor, is going around from dorm to dorm to make sure the airmen on duty are following procedures. The TI knocks on the door and demands entry. For whatever reason, the airman lets the TI without asking to see ID. The TI blows a gasket and starts screaming at the airman about how much trouble he's going to be in when the TI reports what happened. He demands the airman hand over a Form 341, which is used to document rule infractions. Airman: Sir, I'll give you a 341, but I think you should know the store is broken. TI: What the hell are you talking about, Airman? Airman: Sir, we found out that if you kick the door in the bottom left corner, it opens whether it's locked or not. TI: Show me what you're talking about. The two step out into the hallway, and the airman shows the TI where to kick the door. Airman: Sir, let me step back inside and lock the door so you can try it out yourself. The airman steps back inside the door, then locks it. The TI tries kicking the door, but it remains locked. TI: Airman, I thought you said the store is broken. Airman: Huh, it worked the last time I tried it. TI: Well, it looks like it's working fine now. Open up and give me a 341. Airman: Sir, if you're requesting entry to the dorm, I'll have to see your ID first. Story 8. Over 10 years ago, I was at fault for rear-ending someone else. I had no insurance and my license is expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but he wrote me a ticket for it all. One was kind of a fix-it ticket about my suspended license. I sorted that out in the days after and nothing came of it. The cop had mentioned that he had to write the insurance ticket, but I had to take it into court and get it lowered. I was so desperate to try and get my $800 insurance ticket lowered because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me, and said, "I would like to use Mr. South Seattle's case as an example to the gallery." I almost fainted. It went on. "This is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. South Seattle accountable for this." My jaw dropped. I stood there. The judge told me I was free to go twice before I registered. I'm pretty sure that the cop deliberately didn't write the date in that ticket. Thanks, officer. Story 9. I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside drawer, walked into his living room, and confronted a figure in the dark. The person didn't identify himself but moved towards my client, who fired a single shot. It turned out it was my client's stepson who had snuck out, been drinking, and stumbled home. The problem with the situation was that my client had been convicted several times in the past. That meant that while the shooting itself was legally defensible, his possession of the firearm was not. We looked into the history of the gun itself, as our client had indicated it had belonged to his grandfather, who had served in the U.S. Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the very first batch of firearms distributed from Colt to the U.S. Army at Augusta Armory. Florida Statute 790.001 creates an exemption for firearms-related laws, including the prohibition for felons to possess a firearm if the firearm in question was an antique, meaning it was manufactured before 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potential mandatory prison sentence. Well, he's gonna need a divorce lawyer too after that one. Story 10. I had a client who was a truck driver. He got various penal infractions for issues with his truck, several $1,000s in fines, basically. Anyway, the evidence is pretty damaging. Lots of pictures showing defects, detailed descriptions by the traffic control officer, and so on. However, to find him guilty, the prosecutor technically has to prove that the vehicle he was driving is considered a heavy vehicle. The law says, 3. Heavy vehicle means A road vehicle or combination of road vehicles, within the meaning of the Highway Safety Code, having a gross vehicle weight rating or gross combination weight rating of 4,500 kg or more. B. A bus, minibus, or tow truck within the meaning of that code. C. A road vehicle subject to a regulation made under Section 622 of that code. The traffic control officer had not listed the weight of the vehicle in his report. There are pictures of it, clearly an 18-wheel truck in the report, but no weight is written anywhere. So I told the judge that the prosecution hadn't proven the weight of the vehicle per the definition of heavy vehicle. The pictures don't prove the numerical weight, just the shape of the vehicle. She had no choice but to acquit him because all the infractions he had received were for a heavy vehicle operator. So he can't be guilty if they can't prove he was operating a heavy vehicle. Great. Now that you've heard about the quirky laws that secured some wins in court, how about a challenge? Hop over to Lawyers. What case was impossible to defend? And see how Story 3 was so emotionally difficult for both parties. It was traumatic, to say the least. See you there.